Third argument this morning is going to be in the case of State of Ohio versus Kyle Morabith. It's case number 21CA011778. Panel, of course, is Judge Hensel on my right, Judge Sutton on my left. I'm Judge Theodosia. I'll be presiding here this morning, keeping track of time. Each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you let me know, I'll keep track of that time for you and probably interrupt you to let you know as you get close to that time. You can decide to continue on or save whatever time you have left for that rebuttal. The court has a rule concerning the use of the names of children, minors, and victims. We ask that you not refer to them by name, but use initials or some other means of identifying the child, that sort of thing. The arguments are recorded, so we also ask that you stay at the podium and keep your voice up so we get a good recording for those who may be interested in watching it on the YouTube channel. Judge Hensel, Judge Sutton, and I have all read the briefs, and we are prepared to proceed. How much time would you like to reserve if you are going to reserve time?
I will reserve 5 minutes, Your Honor.
5 minutes. All right, I'll let you know as you get close to that, and I know you're not Michael. So.
I am not. I'm his associate, Alyssa Barbosky.
All right, if you want to get started, we'll hear from you.
Good morning, Your Honors. My name is Attorney Alyssa Barbosky here on behalf of Appellant. Your Honor, just briefly, this is a case where the appellant was convicted by a guilty plea of aggravated vehicular homicide. Your Honor, basically, this did not go to trial. Mr. Morabith pled guilty, and he was sentenced. Our argument is based on that sentencing hearing. Based on what you're going to hear, I think it's clear that you should review this case by a clear and convincing standard, and that it should be reversed and remanded for reconsideration on his sentencing. Your Honor, the record in his sentencing supports this, that Mr. Morabith was going, very fast that day. We understand that. He was got into a car accident, and the deceased, the victim in this case, was unfortunately immediately killed on scene. There is nothing that anybody could say or do to minimize the seriousness of this case. Everything involved in the case is absolutely devastating. However, Your Honor, there was nothing in appellant's history, anything in the factors of sentencing that should determine that he should have gotten a 40-year prison sentence or any prison sentence at all. In our sentencing at the trial court, we provided a sentencing memorandum which had a chart similar to the one in our brief, except it was a lot more cases, including everybody from 1996 all the way up till Mr. Morabith's case, that showed that all the sentencings for aggravated vehicular homicide. All the cases that included a prison term had some exacerbating facts, exacerbating circumstances, whether it was aggravated vehicular homicide with texting and driving, with an OVI, fleeing the scene, a hit skip, something of that nature, as outlined in our brief. Appellant did not have any of those circumstances here. This was
Counsel, was a PSI ordered in this?
It was, Your Honor.
Case? And is that included in the record?
It is not, Your Honor.
And do you want to expound on that?
Your Honor, so in preparing for this, I don't know exactly why it wasn't included, but they did do a PSI to show that he had no criminal history whatsoever. He had some minor traffic of speeding, seatbelt violations of that such, but other than that, it showed that appellant had very great family support, no criminal history, nothing in his judicial history, that he was in college, and that was pretty much.
I mean, when I say, do you want to expound on that, I mean in terms of why it might not be in the record.
Your Honor, I don't know if we actually requested it to be part of the record, and I think that's an error on our behalf. I don't know if Attorney Stepanek actually asked for it to be part of the record, because I think he was focusing just on the sentencing factors. So, Your Honor, I think that we're focusing on what does 292911B mean when they say that there needs to be similar sentences? We cited State versus Quinn, which talks about how it doesn't have to be uniform, and we're very understanding of that, and that there's, every case is fact specific, and that's what the judge in the trial court used. However, they say that there needs to be something consistent to where it can be predictable, where it can be something that's not so out of the ordinary that, it's not within the realm of what that county and jurisdiction has done in the past. And as I've stated, we looked through all the cases from 1996 until present, and there was nothing to state that Mr. Morabith would have gotten a prison sentence. Nothing in his record. There was no recidivism factors that were found. Like I said, he had no criminal record. So what does consistent mean? In State versus Quinn, they actually brought up the argument of that, a judge has the discretion to use the prior sentences and research. It's not on the trial court to do their own research, which is why we did it on their behalf. And that's why we're distinguished from that case, is because we did that research. We provided it to the court and the prosecutor for the sentencing memorandum, and we showed them that this was not consistent. This is not something that had been, prison was not something that was consistent with all the other aggravated vehicular homicide cases, unless there were some sort of exasperated facts or other charges along with it. And so in Quinn, they said that you could use that prior research that had been done if it's brought up by counsel, and that's something that could be preserved for an appellate argument if brought up, and that was our main objection at the end of sentencing, was that this was not the precedent, this was not consistent. So we're challenging what, if anything, then does consistent, what is that supposed to mean if it's not something that's predictable, as the courts have stated in Tucker and in Quinn. Again, there's nothing.
Counsel, excuse me, did the court acknowledge or reference the materials that you provided as far as the chart of the case files?
Your Honor, when we brought that up, they basically said that the judge could think of one case where somebody went to prison, which was State versus Emory, and that was actually also in our brief, and that's one where we had went back at the court and said, well, unfortunately in that case there was a hit skip involved. The guy fled, so that was how we distinguished it from that, and that's the only thing that the judge brought up during that. I know the prosecutor tried to bring up a different case, Ms. Young, and which also happened to be in this jurisdiction, and we said that unfortunately that was a texting and driving scenario, and there was 2 victims involved, a minor who was thankfully not killed, but the mother of the minor was driving and she drove into the house. So that one was distinguished as well because they found some metabolite, not enough for an OVI, but again it was texting and driving and also some sort of metabolite and 2 victims involved. So in our case, the other thing is the judge brought up that he considered that our guy was 30 years of age and not 20, 19, 18, even though that's not in the sentencing factor guideline, and that he should have just known better. Unfortunately, I guess that could be said of every criminal defendant, that they should have known better, minus maybe a juvenile. And so we don't think that that was fair that that got used against our client, because that's not in the sentencing factor guidelines, and that's not something that, although it's obviously sure that can be used, it's up to the judge's discretion, that's not consistent and not something in the sentencing factors, and that's something that the judge repeatedly highlighted.
Counsel, didn't the judge with respect to that say that the sentencing laws, quote, tell us as judges to consider the youth of the offender if they are young, because they haven't lived long enough to have good judgment? And so he did bring it up in the context of what might be a differential with a youthful offender.
Sure, and I looked into that, and I tried to find that. I did find that the age of the victim could be considered, but I think in this case, we see a range of offenders all the time in court, unfortunately, and I think that there are plenty of younger and older people who have similar, maybe worse offenses that didn't get taken into consideration, or they weren't I've never heard a judge say that they should have known better or that they should have, I think this was an accident and it was based on reckless, not, a knowing state of mind. So with that, we would just be asking that because of the dissimilar sentences in the last 25 years, as far back as we could get records, that this case should be reversed and remanded on clear and convincing evidence. Thank you, Your Honor.
Let me just check if Judge Henson, do you have any questions? Okay, very good, thank you.
Thank you, Your Honor.
You'll have a full 5 minutes because
Perfect.
for your rebuttal. All right, counsel, you have 15 minutes.
Good morning, judges. May it please the court, my name is Rick Raley. I'm appearing today on behalf of the appellee of the state of Ohio and Lorain County Prosecutor J.D. Tomlinson. This court should affirm the trial court sentence of 4 years for aggravated vehicular homicide, and there's no clear and convincing evidence in the record that's unsupported or that's contrary to law. And likewise, the appellant, I'm going to focus on the first assignment of error. The second and third should be easily overruled as well, but to streamline our approach today, I will focus on the first. And really, consistency in Ohio sentencing is really, we created it through two means. Number one, there's a statute that outlines the prison terms for an offense. In this case, it's an F3, a high-tier F3, vehicular homicide. It's from 1 to 5 years. The trial court issues a sentence that's within that range. We have consistency there. The second one is that each judge in this state has to require the same types of factors in issuing a sentence. There are seriousness factors, there are recidivism factors. And when we look through the trial court's transcript here, it's quite clear that the judge was thinking about those factors, and he mentioned his consideration of them quite clearly on the record. And the appellant concedes this. Consistency does not require uniformity, except there's divergence. And this court in Babb, which is 2007 Ohio 5102, says two defendants with the same offense that they're convicted of and identical histories of recidivism can receive different prison terms properly. And that's because of all the fact-by-fact, case-by-case, fact-intensive inquiries that trial judges have to do. So in this case, the trial level, the appellant showed up at the sentencing hearing and just provides a laundry list of purportedly similar cases and says, look at these. This says, Judge, actually you don't have discretion under the revised code. You have to issue a community control sanction because there has to be some sort of exacerbating circumstance of an OBI offense or hit skip. That doesn't exist in the law. And in fact, if there have to be requirement of exacerbating circumstances, I think there are here, even if there isn't an offense for it. We have that a young man lost his life because of very reckless behavior. 100-mile-per-hour speeding on 45-mile-per-hour country roads. And this is the most important, I think. He continued and he persisted in this conduct after the victim and the victim's fiance both say, stop. At the trial level, the judge heard all that, and that's why he said, you should have known better. He was told to do better, and he persisted in any ways. Now, the trial judge also notes this laundry list, these cases aren't always all similar. They have very different circumstances. There's no indication the conduct is alike. All it is a simple list of convicted offenses. That's not enough to show the consistency based on your standard of review. So with that, judges, I'd ask for any questions, and if not, I'd ask for you to affirm the trial court sentence.
What, if anything, is the Court of Appeals to make of the statement that's on the record regarding judicial release?
I'm approaching it.
Argument, go ahead.
I'm approaching it as it's a 4-year sentence right now, and that's within the range that's allowed for it, and based on the factors, that's appropriate every day of those 4 years. The judge, in his discretion, because we do provide discretion to trial judges, he's decided because of the history of recidivism, I'm going to consider him, sort of the lack of history of recidivism, I will consider him for judicial release. So, it's something the trial judge did, and it's something to keep the offender rehabilitated when he's incarcerated. But I'm approaching this as it is a 4-year sentence, and that is still appropriate.
Thank you.
How about the provision in the statute of the courts to use the most minimum sentence that is available, that doesn't burden the system? When you look at his recidivism factors, no prior record, not on probation at the time, seems like he showed genuine remorse. This was in a situation where he was in intoxicated, driving under intoxicated, pled guilty, taking responsibility. And when you look at the factors, there's some compelling arguments that the defendant had to indicate he should have gotten something less than a 4-year sentence.
And the trial court noted those on the record that he considered those factors, and he did not get the maximum, so he did receive consideration for those factors. I would again return to these seriousness considerations. The conduct involved is just so serious, and it's a charge that involves reckless conduct, but really, with being told twice to stop, it's almost knowing conduct in this case. So I think it's totally fine for the trial judge to rely on those seriousness conduct to give a 4-year sentence in this case.
Judge Sutton, any questions?
Do you know?
Judge Hessel? All right, thank you very much for your argument today.
Thank you, Judge.
Let's see, counsel, you've got that full 5 minutes for rebuttal.
Thank you, Your Honor. Something I wanted to touch on is the seriousness. Like I stated before, every aggravated vehicular homicide is going to be serious. There's no doubt about that. That doesn't mean that just because there is a deceased victim in the case that it mandates a prison sentence and there's a presumption of prison. Again, we outlined cases where there were other, aggravated vehicular homicides and people got probation. The state states that, there was 100 miles per hour, and that's actually something that was disputed at sentencing without going into, obviously, a trial. We had stated on the record that at times the deceased fiance, who was also in the car at the time, stated to police that he was going, the appellant was going 90 miles per hour at certain times, and when asked, how close to the accident was he doing that, she said maybe a minute prior. Now, we have no, obviously, way to know if exactly what the speed was at the time. The state said that. There was an accident reconstruction, but there was no way to determine exactly how fast appellant was going at the time of the accident. But based on our record, we just have that he was going 90, maybe a minute prior to that accident. And so we don't know what the speed was. It certainly wasn't 100 miles per hour, but the victim's fiance did say that he had slowed down when taking the curb. So we do believe that there were, it was a slower speed than that at the time. And that's the best that we have. In fact, there's not exacerbating circumstances because when the police asked the decedent's fiance if her and the victim knew that, this was kind of supposed to be a joyride and where appellant was going to show his car off and go faster than the, speed limit, she said yes. And they said, do you think that the decedent knew that he was going to be speeding that quickly? And she said yes. So she was honest with the police and said that we knew going into this car that he was going to be going very fast. And that this was going to be a joyride. So I don't think that it was a knowing, mens rea. It was based on the recklessness. And in fact, I think, like you stated in one of your questions, what to think of the judicial release. I think that it's like the judge wanted to say, hey, there's no recidivism, more serious factors here. There's lack of recidivant factors here, but I, feel bad for the victim and their family, so I'm going to give you a judicial. He pretty much said on the record, the judge said that he would guarantee a judicial after 1 year if appellant did not have any misconduct while in prison and did not have anything else between then and sentencing. And he did not, and so, Your Honor, the judge pretty much said that there's no recidivism factors and that this was not more serious than others by saying that he was going to give him a judicial release after 1 year, pretty much guaranteed. And again, I would just say for the record, it's pretty clear that he should have gotten a probation sentence because, there's no criminal record. There was genuine remorse. Appellant was shedding many tears and has in the past. That was clear to the record. The judge even stated that, appellant had genuine remorse and he believed that that remorse was real and was believable. This was his childhood friend. He is facing in his head a life sentence. Unfortunately, there's nothing that he'll ever be able to do to get over the fact that, you know, he got into this accident and that his best friend, who had been his best friend for life, had died. He's facing enough punishment. We understand that, again, this is serious, but again, there was nothing else on the record, no exasperating factors that showed that he should have gotten something more than a community control sanction and a license sentence that he received. Thank you, Your Honors.
Questions? No? All right, thank you both for your arguments today. We'll take the matter under advisement, issue a decision in due course, and make sure that each of you receive a copy of the decision on the day it's released. The opinions are also posted on the Supreme Court of Ohio's website, so you're free to keep an eye out there as well. Thank you for your arguments.